I certainly appreciate the opportunity to be here in this beautiful setting. During the time that I've been on the PCAOB, I've participated in 2 NASBA annual meetings and several other NASBA events, and it's always a great opportunity to learn some things and share opportunities and experiences with other people that care about audit quality and have a role to play in that field. So I'm very glad to be here. I thought what I would do today, my topic is billed as a PCAOB report, so I thought what I would try to do is summarize some of the things that are on our current agenda. As a number of other speakers have pointed out, the financial crisis has raised questions, or in some cases re-raised questions, about the role and relevancy of the auditor's work. Audit regulators, both in the United States and abroad, are grappling with those questions now. Certainly, in my view, as others have said, while auditors didn't cause the financial crisis, and I don't think that better auditing would have prevented the crisis, it has led to a rethinking of what investors expect of auditors, and that's driving a lot of the agenda both in the United States and across the world. I think the crisis also highlighted the need for us to focus on international cooperation and sharing of experience and working together among audit regulators, and I'm also going to talk a little bit about our activities in that area. As the slide indicates, I'm going to group my comments into 2 basic areas. First, our agenda for improving audit relevancy, transparency, and the independence of auditors. And that includes things like modernizing the auditor's report. I think you've already heard from others about our project on the auditor's reporting model. I'm also going to talk a little about a related project that has to do with transparency or disclosure of the firms that are involved in multinational audits and the identity of the engagement partner. We also have some initiatives going on related to the role of the audit committee and trying to strengthen the role of the audit committee. I'll touch on those, and comments that our chairman has made about bolstering auditor independence and professional skepticism. Then second, in the international area, I'm going to talk a little bit about the status of our international inspections program and about our work in IFIAR, the International Forum of Independent Audit Regulators, which Mike just referred to in his introduction. Before I do all that, of course, no presentation from anybody from Washington would be complete without the warning that my views are solely my own, not necessarily those of the board and its other members or staff, so consider yourselves warned. First, the PCAOB's agenda with respect to, well, I guess what I would broadly call audit quality, enhancing audit relevancy, transparency, and independence. Certainly the most important thing, I think the thing with the greatest far-reaching potential on our agenda is the project to rethink the auditor's reporting model. Essentially, the auditor's report really hasn't changed in many years. As you're all aware, it's a standardized report. I guess critics would call it a boilerplate report that identifies the financial statements that were audited, describes the general nature of the audit, and presents the auditor's opinion that the financial statements taken as a whole fairly present, in all material respects, the company's financial position and the results of operations. It's what people call a pass-fail report, and you don't see failing reports very often. I thought that Rick Murray was quite articulate in describing the reasons related to liability, why the report looks the way it does, and I certainly would say at the beginning that I think we appreciate that liability ramifications will have to be given careful thought if there are any changes made in what the scope of the auditor's reporting responsibilities. That having been said, again, as I've already mentioned and others have said, the financial crisis has raised questions about whether auditors should or could have done more to alert users of audited financial statements to the risks that companies, particularly financial institutions, apparently were running in the years leading up to the crisis. Again, I mean, I think we could debate at some length the merits of those concerns or whether they're well-founded, but there is a certain element that at the end of the day, I think the auditors have to give serious thought to whether the users, the consumers of their product, are satisfied with what they're receiving. One of the members of our standing advisory group, Professor Carcello, Joe Carcello, did an informal survey of users, largely institutional investors, about their view of the audit report. I've picked out on this slide two of what I consider to be the most surprising findings from his survey. 45% of the respondents believe that the current audit report does not provide valuable information that is integral to understanding financial statements, and 18% said they thought the auditor's report was of no use to them at all. I think, at least I hope, that doesn't reflect a view that the audit is not of value to the users of financial statements and to investors and the markets generally. I mean, I hope that people recognize generally how much the willingness of people to commit capital to public securities markets depends on the additional confidence in company financial reporting that the audit provides. But still, I think these are kind of sobering statistics as to the fact that auditors think that they should be getting more, in some sense, more from auditors. Users think they should be getting more from auditors in terms of insight into the audit or into the company itself. This view is also influencing the work of other audit regulators around the world. There have been a number of studies of the role of auditors leading up to the financial crisis. I think these projects have also been referred to already by other speakers. The House of Lords in the UK did a report on the auditing profession, which they say that investors and others demand that the audit should provide broader, more up-to-date assurance on such matters as risk management, the firm's business model, and the business review. The EC's green paper raises issues about whether information of public interest that's available to auditors should be communicated to the public, such as the company's exposure to future risks or events and the auditor's economic and financial outlook for the company. I think it's striking that both of those reports are raising the possibility of auditors providing information about the company that goes far beyond the kind of assurance about the information management's providing. It gets into the auditor's view about the risks the business is exposed to and almost would make the auditors akin to a financial analyst. The IAASB also has a consultation paper out about the reporting model that's, I think, somewhat more sober, perhaps, in terms of the nature of the changes that would be made, but it also recognizes that there are reason to think that the current communications aren't meeting the needs of financial statement users. So, against this background, the PCAOB has also been looking at this issue for several years now. Our work really in this area emanates from the ACAP report, again, which was discussed on the first panel this morning. It's a report that our Treasury, the United States Department of the Treasury, convened an advisory committee on the future of the auditing profession, or on the auditing profession. It produced a report in, I guess, late 2008 that contained a variety of recommendations, some of which were aimed at the PCAOB, and one of which involved possible changes in the auditor's report. We've discussed this topic with our standing advisory group on a couple of occasions, and that led to a series of focus group meetings that we had with financial statement users, with preparers, with auditors, with academics, to try and gather ideas, information about how the auditor's reporting model might change, and all of that culminated then in the concept release that we've issued on June 21st of of this year. It's called a concept release because it doesn't actually propose any changes in the auditor's report. It simply exposes for public comment some alternatives, some possibilities. Presumably then, based on the feedback that we get from the concept release, we'll decide whether to go on and propose changes and what the nature of those changes should be, or conceivably whether there should be no change in the auditor's report. The concept release lays out, along with the background and the kind of things we heard at the focus group meetings, 4 basic alternatives about how auditor reporting might change. The first is that there would be a required auditor's discussion and analysis, I suppose sort of generally akin to the management's discussion and analysis that public companies in the U.S. are required to prepare today. This is certainly the most expansive, and I suppose you could say far-reaching of the alternatives that we raise. While there's no firm or single definition about what the AD&A might contain, the sorts of things that might be discussed would be the auditor's perception of the audit risks associated with a particular engagement, what audit procedures were used in order to address audit risks, what are sometimes called close calls or contentious issues, what were the difficult judgments that had to be made as part of the audit, or the decision whether to issue the audit report or in what form to issue the audit report. Perhaps the auditor's views about things like the management's estimates and selection of accounting principles and the judgments that management had to make in reaching those decisions. Creating this kind of requirement would require that many issues be addressed. And first, I think from the perspective of the large firms, the idea of having a free writing component to every audit engagement raises a lot of concern about what the quality controls would be that they would have to put in place around that, whether you could really have hundreds of partners around the world simply putting pen to paper and creating their own answers to these kinds of questions, how there would be some consistency and standardization in what was expressed. And it certainly also raises questions about where the role of management ends with respect to providing information to users about the company and where the responsibilities of the auditor ought to begin. The second alternative is the required use of emphasis paragraphs in the auditor's opinion. That I think would be a bit of a, if not a compromise, a way of asking the auditors to provide additional information, but without some of the risks and problems that would be associated with the AD&A approach. Auditors certainly have the ability today to include emphasis paragraphs in their opinions, and I think the auditing literature gives examples of things like related party transactions or subsequent events as the sorts of things that might be the subject of emphasis paragraphs, although they're not usually seen. Cindy Fornelli mentioned that the CAQ has sent a comment letter to the board that includes some ideas about changes in the auditor's reporting model. One of the things that they outline in there is the expanded use of emphasis paragraphs. And I think the CAQ model opinion in that letter has emphasis paragraphs for things like uncertainty about the ultimate allocation of acquisition costs to goodwill and other intangibles. Companies need to refinance debt that had been incurred on a short-term basis in connection with an acquisition, unfavorable trend in past due receivables or obligations from customers, that type of thing. And in each case, the emphasis paragraph is keyed to a disclosure that the company itself has made. So the auditor isn't supplying new information. He or she would be drawing attention to something that management itself is already presenting. The third alternative that we have in the concept release is expanding the scope of the management information as to which the auditor provides assurance. The I guess, most common example, or the first example here, is that there would be some sort of auditor opinion or report on the management's discussion and analysis, perhaps indicating that it's complete, that to the extent it's based on information from the company's books and records, that it's accurately drawn that information from the books and records, and that where there are forward-looking statements or other kinds of statements in the MD&A that are based on management assumptions, that those assumptions are reasonable. Possibilities also raised in the constant release of auditor association with earnings reports or with earnings releases, or with in situations where the company makes public non-GAAP measures of some sort. And then the fourth alternative discussed is that there would be clarification of language that's in the standard auditor's report. Phrases like reasonable assurance, perhaps there should be some explanation or greater explanation of what that means, explanation of the scope of the auditor's responsibility to search for fraud or to identify fraud, and limitations on the auditor's ability to find fraud, discussion of the auditor's responsibility for the footnotes in the financial statements, discussion of the auditor's responsibility for financial disclosures outside of the financial statements themselves. So that's a bit of a summary of the sorts of things that we've raised questions on. The release does also recognize that all of these alternatives would raise their own questions about the scope of the audit effort, that is the cost of the audit. Presumably they would all to some extent increase audit cost, except possibly the last. We ask about the liability ramifications. Again, as I indicated a minute ago, I think we're well aware of the fact that particularly in the United States legal environment, many of these possibilities, these alternatives would change the scope of the auditor's liability, or could change it. We raise questions about the relationship between the auditor and management and their respective responsibilities to make disclosure, how those things would be impacted, and what impact there might be on the auditor's relationship with the audit committee, particularly to the extent that the impact of the proposals, the AD&A proposal, is to have the auditor making public information that today is conveyed to the audit committee in a non-public setting. So we anticipate having a roundtable on these issues in September of this year, and we'll see where we go from there. The second thing that I wanted to talk about under this heading is a related set of possible changes to the auditor's report, but somewhat more narrowly focused. Changes that would provide additional information about who participated in the audit. And this idea kind of breaks into two parts. The first is that we would require disclosure of the firms that participated in the audit. Obviously, for many audits of multinational companies, or I suppose all audits of multinational companies, a significant portion of the audit work is performed by firms located in a country other than the country of the auditor who's signing the audit report, the principal auditor. Often these firms are part of the same network, the same global network as the principal auditor, although in some cases auditors also rely on firms that they aren't otherwise associated with, that are retained specifically to participate in a particular audit. I think we have some concerns that today that process or that involvement of multiple firms is largely invisible to the readers of the auditor's opinion, to the users of audited financial statements, and that it would be beneficial for users to understand that. And again, the CAQ report, I think, picks up on this idea and would provide for disclosure in at least general terms of the fact that other firms participated in the audit and what the, I think the CAQ's version has a percentage of assets or revenues that were examined by firms other than the principal auditor. I think that this kind of disclosure would also shine some light on the different regulatory regimes and inspection regimes that participating firms might be subject to, although in order to accomplish that, it couldn't be a general disclosure, it would have to be a disclosure specifically of the firms that were involved and their degree of of participation in the audit. So that's the sort of thing we're looking at in this area. Kind of a companion idea, or what I would view as a companion idea, is disclosure about the identity of the engagement partner. This is also something that originates with the recommendations of the Treasury's ACAP report to us. The board received a recommendation from ACAP that we require the engagement partner to sign the audit report in his or her own name, along with the name of the firm. And this is something that I guess is common, at least in, I guess in all of Europe, or in some parts of Europe, but is not something we've ever really had in the United States. We issued a concept release on that idea in 2009 and received comment back from the public. It was quite mixed. I think at the investor level, investors feel almost on a visceral basis that the engagement partner should be taking personal responsibility for the results of the audit and therefore ought to be signing the report in the same way that corporate CEOs and CFOs are required to certify as to the accuracy of company financial reporting. Firms, on the other hand, I think are concerned that partner signature, well, first may change the liability picture to which those partners are exposed, which could have its own consequences on the way that auditing is performed or who wants to participate in public company auditing, and also that in a way it undermines the quality control systems that the firms have in place, which are designed to make sure that the quality of the audit will be the same regardless of who happens to be on the particular engagement team. One possible compromise, if you will, or way of addressing some of these concerns that we're looking at would be to require that the engagement partner be identified in the text of the auditor's report, but not required to sign separately, and that the identification be in a way to make clear that the opinion is coming from the firm, not from the individual engagement partner. So again, these are ideas that we're looking at, the identification of participating firms and identification of the engagement partner, and I think it's quite possible you'll see something from the PCAOB on these ideas probably later this summer. The third topic I wanted to touch on just briefly is things that we're doing to strengthen the role of the audit committee. Certainly one of the premises of the Sarbanes-Oxley Act was to put the audit committee at the center of the relationship between the auditor and a public company client. And I think that audit committees have changed over the past, well, nearly, I guess, 9 years now that the Sarbanes-Oxley Act has been in effect. Still, I think there may be a long way to go in strengthening the audit committee's role, and we're thinking about what we can do in order to promote that. We have some proposed standards out that have been out since 2009 that would strengthen the communications requirements, that is what the auditor is required to communicate to the audit committee, particularly with respect to audit risk and how the auditor plans to address that in the course of the audit, and in general to try to improve two-way communications between the auditor and the audit committee. At the same time, I think we've heard back in comments that we need to be careful not to make audit committee communications more of a sort of a box-ticking exercise, to use a phrase that we heard earlier today, and that what you really need is both auditors and audit committees to be thinking about the communications, not simply receiving more of them or receiving a longer checklist of them. A related issue that we're thinking about is what we can do to help audit committees understand the PCAOB's work, and specifically the inspection reports that we issue on their auditor. Our reports, for statutory reasons, are somewhat less than totally informative about what the PCAOB's views were of the firm. The public part of the report generally would only discuss serious audit deficiencies. The part of the report that discusses firm quality controls we are not able to make public. But we do think audit committees ought to be asking their auditor about those subjects, about what the PCAOB's report means and about what our concerns were about the firm's quality controls and how that might affect any particular audit. And so we may also be putting something out to help audit committees in that area during the coming months. And then finally, I just wanted to touch on the broad subject of auditor independence and professional skepticism. I guess I would say independence in fact and professional skepticism. As has already been mentioned here this morning, our chairman, Chairman Doty, has raised concerns about the number of instances in which the board sees audit failures that would appear to reflect a lack of skepticism, accepting management representations at face value without checking underlying assumptions, maybe at a more severe level, situations where the company has already issued an earnings release. The auditor then discovers some issue that would suggest that the earnings that have already been disclosed would need to be adjusted, and then cooperates in companies' efforts to find offsetting adjustments or something that will prevent the company from having to change what it said publicly. There are other kinds of examples that could be given. In 2003, as a result of the Sarbanes-Oxley Act, Congress directed the GAO to do a study of the possibility of audit firm rotation, that is, mandatory change in the audit firm after a period of years. GAO concluded that it would not recommend that at the time of that study, but suggested that the SEC and the PCAOB would need some experience with how the other reforms in the Sarbanes-Oxley Act were operating in order to reach a decision about whether there ought to be mandatory rotation. The board, of course, has been in operation now for about 9 years. We've been conducting inspections for, well, I guess for all of those years at some level, and we have a fairly large body of inspection findings at this point. So I think it may be a logical time for us to take up what GAO implicitly expected of us and look again at the topic of firm rotation. Chairman Doty has been fairly outspoken on the subject. I put one of his quotes up on this slide. So far, the board itself, the board as an entity, has not said anything about rotation, but we are certainly thinking about what a project in this area might look like and what the best way to kick it off would be. Let me just finish then with a couple of comments about international cooperation. I mean, obviously, as I've already suggested, many U.S. public companies have operations in more than one country, and therefore multiple auditors are involved in their audits. There are certainly also many companies that trade in the U.S. markets that are audited by firms that aren't based in the U.S. We have an active foreign inspection program, and I think we've learned through that the quality of audits it can vary from jurisdiction to jurisdiction, even though firms are part of a single audit network, part of a single global firm. We need the cooperation of other audit regulators in order to be able to look at that work, and that's something that we're working very hard to obtain. We have registered firms in 88 countries. We've conducted inspections so far in about 33 jurisdictions outside the United States. And wherever we can, we inspect jointly with the home country regulator. But nonetheless, there are some fairly large holes in our current non-U.S. inspection program. We can't inspect in, well, I guess in any of continental Europe, or at least the EU member states. And we're not able currently to conduct inspections in China. We did in the past year reach new agreements with the United Kingdom and with Switzerland, so we've resumed inspections in the UK, which we performed previously, and we are conducting inspections in Switzerland. And we're talking quite actively to the EU member states, and I'm hopeful that there will be other agreements in Europe forthcoming before too long. We're also, as there's been some publicity about, involved in a dialogue with our Chinese counterparts. A delegation from the PCAOB and the SEC traveled to China 2 weeks ago to talk about laying the foundation for PCAOB inspections in China. I think the stage we're at now is that there needs to be more, I guess what I would call confidence building, that the Chinese authorities might like to observe some of our inspections and how we inspect in the United States, perhaps would let us do the same thing in the PRC, all, I would hope, with a view to eventually the PCAOB conducting inspections in China the way we do in many other countries. There's been a lot of publicity lately about Chinese reverse merger companies and some of the accounting issues that many of those companies face. And I think, frankly, that's created some pressure, or at least some interest on the part of the Chinese officials to increase public confidence in financial reporting of Chinese companies that trade outside of the Chinese markets. And I think that's opened the door to additional dialogue. So I hope you'll be hearing more about that subject before too long. We certainly recognize that we have to be able to work with our foreign counterparts, and they have to be able to work with us in order to accomplish our goals. At the same time, I think we are sensitive to the fact that because there are places where we can't inspect, we have to respond to that in some fashion, consistent with our investor protection responsibilities. And we've done a couple things in that area over the past year, considering others. First, we've tried to make it as transparent to people as possible where we can and can't inspect. And if you go to our website, you'll be able to find out that information, and you'll be able to identify the firms that are registered with us in countries where we are unable to conduct inspections, and who those firms' audit clients are, at least according to the registration information they file with us. Beyond that, we announced last fall that we were no longer going to register new firms from jurisdictions where we don't have the ability to conduct inspections. At least we were not going to routinely register new firms. So currently, when we receive a registration application from a firm based in a jurisdiction where we can't inspect, that will either be held in abeyance until we are able to inspect, or if the firm requests it, it'll be sent to a hearing before our hearing officer, where the public interest factors can be explored as to whether registration should be granted. I hope that will end soon, and we'll be back to being able to inspect everywhere where there are registered firms, and we won't have to take that sort of action. And as I've mentioned already, we're also considering requiring disclosure of the firms that participate in U.S. issuer audits, and that would be a way of giving people more insight into the inspection status of all of those participating firms. Finally, just very briefly, before I run out of time here, I did want to say a few words about our participation in IFIAR, the International Forum of Independent Audit Regulators. Since the PCAOB was created in 2002, many other countries have also created generally similar oversight bodies that are charged with overseeing and inspecting the work of auditors in their jurisdiction, and bodies that are independent of the profession themselves. These independent regulators, as in the United States, have generally replaced peer review or similar inspection regimes that were performed by the members of the profession. IFIAR was created in 2006 so that these independent audit regulators could get together and have a vehicle to share ideas and experiences and assist each other in the development and execution of their audit oversight programs. IFIAR today has 38 members. Paul George, the Director of Auditing at the UK's Financial Regulatory Council, is the chair of IFIAR, and I am the vice chair currently of IFIAR. So the PCAOB is very much involved in IFIAR's activities. As I guess I've indicated, IFIAR is not open to everyone. It does have membership criteria that largely turn on the independence from the profession of auditor oversight in the home country, in the country where the regulator is based. I also stress that IFIAR is not itself a regulator, but it does provide a forum for regulators to get together and discuss common issues. This slide puts up generally the three things that IFIAR identifies as the focal point of its activities: sharing knowledge, the audit market environment, and practical experience among independent audit regulators, promoting collaboration and consistency in regulatory activity, and providing a forum for dialogue with other international organizations that have an interest in audit quality. IFIAR meets in plenary session currently 2 times a year. although I would say most of the real work of the organization is done through working groups. FER has 6 working groups. I'll just list them briefly. The Standards Coordination Working Group, which reviews IAASB auditing standards proposals and assists members in commenting on them individually. FER does not develop common views on auditing standards, so there are not FER comments per se. There's an Inspection Workshop Working Group, which runs an annual workshop at which members can get together with each other and share experiences about inspection programs, share knowledge. There's an Investor Dialogue Working Group, which embodies FER's outreach to investors, to users of financial statements. There's what we call the GPPC Working Group, which maintains a dialogue with the 6 large worldwide global network firms, we call the GPPC firms. The International Cooperation Working Group that shares views about how members can work together to promote their shared oversight goals, and a Current Issues Task Force, which, as the name suggests, talks about emerging issues in auditing. Just as an example, the GPPC Working Group has identified 4 issues related to audit quality that seem to be common among regulators, and asked the large firms to discuss with us how they plan to strengthen or how they are strengthening the quality of their practice around the world in those areas. They are group audits, which is really our phrase that would relate to audits where more than one network member participates, the role of auditor skepticism, strengthening auditor skepticism, revenue recognition auditing, and the role of engagement quality control reviewers. That is a second partner, concurring partner review. Each of the firms has put together information on what it's doing in those areas, and both through the working group and at the FER plenary sessions, we meet with the firms to discuss those issues. Obviously, those issues may change from time to time. Well, that's the end. I hope I've saved a little time for questions. I probably haven't done a very good job of that. I'm just end by stressing that I think there's a lot going on at the PCAOB and a lot going on in audit oversight generally. I think it's an exciting time to be involved in this area because some fundamental changes are likely to take place in auditing and in the auditor's role, and it's important for us all to be part of that process. Thanks very much, and I would be happy to answer any questions if I've left any time for them.
Well, we have a burning question if you have to entertain it real quick, but Dan is here all afternoon and will be available for any questions and discussions you might want to have with him directly. But if there is a burning question, one for the benefit of the group. If not,
Well, get off easy.
Talk to you afterwards.
Thank you very much.